Under company law, legally incorporated business entities have their own legal personality. This means they are considered separate legal persons from their owners or directors. As such, they can own property, employ people, and engage in legal actions, both as plaintiffs and defendants. Because of their separate legal status, companies can commit criminal offenses. Corporate entities can be held criminally liable in several ways, including vicarious liability for the actions of their employees or agents, which we'll discuss in more detail in the next topic. Companies can also be liable for breaching statutory duties, such as those related to health and safety regulations, where offenses are often strict liability. However, establishing liability for offenses that require mens rea, a guilty mind, is more challenging. Determining who has the guilty mind necessary to commit an offense is complex. While the law acknowledges that companies have a legal personality, this is an artificial construct. Companies must act through their directors and other officials, who make decisions and take actions on behalf of the company. For statutory offences created by Parliament, it is necessary to examine whether a specific staff member can be attributed with the required state of mind. For example, insolvency laws may hold certain company officers liable for financial irregularities. Common law offences, especially manslaughter, have been contentious in corporate liability. Can a company be held liable for gross negligence manslaughter if management failures result in someone's death? Historically, prosecuting large companies for gross negligence manslaughter was difficult, because only a controlling officer representing the company's directing mind and will could have the necessary mens rea. Identifying such an individual in large companies proved challenging. To address these issues, Parliament enacted the Corporate Manslaughter and Corporate Homicide Act of 2007, simplifying such prosecutions. However, this area of law remains complex. Companies can also be convicted as accessories or secondary parties to offences. For example, in the case of Robert Miller Contractors Limited, the CEO knew an employee was about to commit an offence, did nothing to stop it, and was prosecuted along with the company. Both were convicted. This case demonstrates the knowledge of a principal offender's intent, combined with the ability to control their actions, and a deliberate decision not to, can lead to a company's prosecution. While companies, as artificial persons, cannot commit certain offences, like sexual assault, as principals, they could theoretically be accessories in appropriate cases. In summary, corporate entities can be prosecuted for various offences, although these prosecutions can be more complex than those involving individuals. Thank you for joining us. Stay tuned for our next video, where we will continue exploring key UK legislation.